Good morning, I am Father X, talking about how fathers can win their child custody case. Today, we're talking about the major mistakes that judges make in child custody decisions. Why does this matter to you? In my last episode, 5A, I shared that the courts are supposed to make decisions based on the best interests of the child, where the starting point is that both parents have equal rights. Many of us start off in family court with a presumption that judges are fair, neutral, and wise. That's the marketing slogan we're all taught. But let's take that marketing slogan and throw it away, because too many of us already know family court isn't fair, neutral, or wise. The key questions are, does your judge actually decide based on the best interests of the child? And if not, how do I force them to? This episode is crucial. I ask you to listen to the entire video because I'll show you the mistakes that judges can make in your case. And then in my next episode, I'll show you a game plan for how to overcome those mistakes. Many people complain that the court is unfair, but complaining doesn't get your kids back. Strategizing and outmaneuvering the judge gets your kids back. So let's get to it. First, we'll talk about mistakes judges make. If you haven't seen my prior episode, 5A, where I discuss the details of the best interest factors, please go back and look at it after this episode. There are 24 factors across 6 categories. We discussed these already, so I'll just quickly flash them here. We discussed 5 factors related to the parent's weaknesses, 6 more related to the needs of the child, 4 items related to the parent's home, 5 items related to prior custody arrangements and co-parenting, 2 items related to the parent's behavior in court, and 2 other factors. And now we'll talk about errors that family court judges make in issuing temporary custody orders and throughout the trial process up until the time they make a final decision. Be aware, these errors can be unintentional or intentional. You have to evaluate that based on your situation. The first one is prioritizing the best interests of the mother and the court over the best interests of the child. You understand the concept that custody decisions are supposed to be made in the best interests of the child. Let's expand our thinking. Decisions can be made in the best interests of the mother or the best interests of the father, and decisions can be made in the best interests of the court or the judge. Nobody ever talks about these things, but they're easy to see once you pay attention to them. What do I mean? Well, let's look at what the best scenario is for each of these 4 parties involved. What's in the best interests of the mother? A mother would love to be automatically granted primary custody of her children with no questions asked, with minimal analysis. And the mother would love to get 17% of the father's income every year for child support. And the mother would love to avoid being the one who has to pay 17% of her income to the father. What's in the best interests of the father? Well, it's pretty much the same exact thing as the mother. Automatic primary custody plus 17% of the mother's income. It's also best for the dad if he can avoid paying 17% of his income to the mother, because 17% of your income is often far beyond the actual cost of raising a child. In reality, that amount of child support is an extremely unfair burden and can lead to financial ruin. What's in the best interests of the child? We talked about this in the prior episode, and this chart summarizes the 6 categories. What's in the best interests of the court and the judge? First, the higher the child support awards that judges hand out, the more federal funding the state gets from the federal government. If this is news to you, don't worry. I'll cover this in more detail in a few minutes later in this episode. Secondly, judges might have thousands of cases every year. It's in the best interest of the judge to churn through those cases as quickly as possible. It saves the judge time if they just don't bother to ask questions about the reality of your child's circumstances. Third, judges want to avoid issuing custody to a parent and then having that parent injure the child, where that story ends up on page 1 of the New York Times. Judges prefer to avoid that kind of negative publicity. Fourth, judges often prefer a safe, temporary custody order, and they often presume that giving the mother custody is a safe bet, even though that's obviously gender biased. Fifth, judges are afraid of having their decisions overturned by a court of appeals, and that's why you and I are going to use appellate court rulings to handcuff the judge. So now that you can see what's in the best interests of every party involved in this custody case, you can interpret who is benefiting from each one of the judge's decisions throughout the trial process. And for example, when you see the judge issue temporary primary custody to the mother based on no intelligent thought, it becomes clear that the judge is acting in the best interests of the mother and of the lazy judge, instead of acting in the best interests of the child. This is a major error and a major abdication of responsibility by a judge. Be on the lookout for it. Before we proceed, here's a reminder to like, subscribe, and share. This will help the YouTube algorithm get this message out to more fathers in our position. The second one is a lack of complete thought. When a judge decides in the best interest of the child, they're supposed to look at the totality of the circumstances. This is a legal term to describe that you're supposed to look at every factor and at the entire picture of the parent's and child's life. A judge can't just pick 2 or 3 factors that justify why they should just rubber stamp the mother for custody and then ignore the rest of the factors. During my trial, for the first 3 years of our trial appearances, the judge just kept issuing a temporary order where the mother would get custody. But the judge never addressed anything about the totality of the circumstances for all the best interest factors related to our son. And the mother's lawyer and the mother herself never spoke about the best interests of our son. Generally, the lawyers just went back and forth, bickering about, "No, I don't want the father to have more parenting time. I want custody exchanges to be at the police station closer to my house, not his house." None of this involved any thorough or intelligent thought about the best parenting arrangement for our son. In my case, the first time we went to court, our first judge gave temporary custody to the mother only based on the idea that the mother was unemployed at the time and available to take care of our son full time. This judge ignored all of the other best interest factors and didn't try to make an effort to understand the reality of the situation. I didn't realize it at the time, but after I learned about the best interest factors and then compared that to what our first judge decided on temporary custody, I realized how completely incompetent and irresponsible this judge's decision was. I mean, it goes completely against how the law and the appellate courts tell you to make custody decisions. How can you ignore 11/12 of the conversation? How do you give somebody custody because they're unemployed when that person is suicidal and violent with anger management problems? And then, a few years later, a close friend of mine found himself in the same position with his baby mama. In his first appearance in court, even though my friend was the unemployed parent and available to care for the child, that factor was ignored, and their judge gave custody to the mother because the mother was able to breastfeed at the time. I have also seen this behavior by judges in the cases of other fathers I have consulted. So it became apparent to me that judges have the ability to cherry pick whatever factors they want in order to justify giving custody to the mother. This is the same deceitful approach that I explained to you in episode 3B, The Weaknesses of Family Lawyers, where I discussed how lawyers look at 1 or 2 factors and hide from the whole truth in order to make the conclusion that they want. Be sure to go back and review that episode. The third mistake is the mindset of laziness. I found in my case that the judges were too lazy to ask questions or think through the total circumstances. Judges often use the excuse of, "I have too many cases, I can't get into the details of each one," and then they just give primary custody to the mother as if it's a safe choice. But that's unethical behavior, and I consider it to be completely against the intent of the law, because if a judge doesn't know the total circumstance, then they can't justify stripping the father's rights and giving primary custody to the mother. They should be issuing 50-50 custody to start if the judge doesn't have enough information about the true best interests of the child. You'll notice that the judge and everybody in the courtroom plays along with the game that the judge is the wisest person in the room and the authority that has all the answers. But in reality, the judge is the most ignorant person in the room. The two parents are the ones who actually know the facts of this case, which is the most important part of deciding child custody. If there are lawyers involved, they'll act like they have something intelligent to say. But even they only know the 25% of the facts that the parents gave them. Meanwhile, the judge has never met either one of you and has never been in your home. So the judge knows nothing. Any competent professional would recognize that they have to go from 0 to 10 in terms of knowledge before making a decision. But in my experience, I have seen family court judges make zero effort to learn the facts, but still issue primary custody to the mother on a temporary basis. In addition, because judges give custody to the mother, historically, 85% to 95% of the time, our society knows that courts favor mothers. This creates an obvious incentive for most mothers to go to court to solve their custody issues, because mothers know they have an advantage. I know the courts are overcrowded. This problem has been created by the courts themselves because they rubber stamped the mother for too long. If courts automatically issued 50-50 custody as a starting point, then you would see the problem of overcrowding disappear over time. Another factor that comes into custody decisions is the straight-out gender discrimination by so many judges in favor of mothers and against fathers. If you pay attention to what our fellow citizens say, it's clear many of them recognize courts are biased against dads. And when you see that courts give custody to the mother 85 to 95% of the time over the past so many years, the statistics themselves reveal this gender bias, so we can't hide from it anymore. So you might experience something where the judge says, the mother is a stay-at-home mom, changing diapers and feeding the baby, and therefore she should have primary custody until the child is 18 years old. And that kind of logic is often used for toddlers to rubber stamp the mother for custody. But actually, that kind of logic is counter to the law, because those needs of the child will only last 2 or 3 years, and then there's another 16 years of things to deal with. So which parent is better for that? Who's going to help the child advance their education and develop emotionally and psychologically into a stable person? When you see this, it's a signal that your judge might be gender biased, because no competent professional would ignore 90% of the relevant facts. Or alternatively, it could be caused by corruption and fraud. What do I mean by that? Many more of us have come to realize over the years that the federal government has a Title IV-D program, where the federal government provides funding and incentive payments to the states if the states collect more child support dollars. You can go to the playlists on my YouTube channel to see videos that expose this. Child support is based on a percentage of income, 17% for example. It depends on the state. If the higher earning father has to pay child support as opposed to the lower earning mother, then the state would have a higher child support order to collect, and the state would get more federal funds. And these federal funds are used to pay salaries of judges, magistrates, attorney generals, and other state workers. So a judge has an economic incentive to make a decision in the worst interests of the child in order for the state to collect more child support. This is why so many people refer to family court as a business and as a corrupt institution. Personally, I like to call it fraud, but that's just me. And to be clear, it's not possible that 100% of judges make these mistakes and behave badly 100% of the time. You have to evaluate how your judge is behaving. And no, they'll never admit to anything bad. You have to infer it from their decisions. But if I had to guess, I would say 80% to 90% of judges each do these kinds of bad things in a majority of their cases. That's based on listening and reading about the industry, in addition to what I have personally seen. The next episode will be how fathers can overcome the major mistakes of family court judges. These might be the darkest days of your life, and I'm making these educational videos to help you navigate this nightmare. If you subscribe, you can get updates when I post more videos. Thank you for liking, subscribing, and sharing with your friends who are in a similar situation. If you like, subscribe, and share, it'll also help the YouTube algorithm get this message out to more fathers in our position.